Good morning. It is 10 a.m. on Tuesday, February the 11th, and I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin the meeting, I'd like to bring to your attention there's a sign-in sheet on the table by the door, and for anyone that would like to make comments about an agenda item, please indicate so by your name as you sign in. Any public comments will be accepted near the end of our board meeting. Ms. Bohannon, would you call the roll, please?
Don Haynes.
Here.
Chris Lee.
Here.
Randy Nash.
Here.
Wendell Naylor.
Here.
Scotty Porsche. Pam Stevens.
Here.
Tim Willer.
Here.
Mr. President, we have a quorum.
Thank you, Ms. Bohannon. First thing on the agenda, I'll accept a motion and a second to adopt the agenda for today's meeting.
So move.
Second.
Have a motion by Mr. Wheeler, a second by Ms. Stevens. All in favor respond by saying aye.
Aye.
Any opposed? Motion carried. Next, I'll ask for an approval of the January 14th, 2025 board meeting minutes. They were in your email or your packet. If anyone needs a second to review, please do so, and I'll ask for a motion and a second on that.
I make a motion we accept.
Second.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. All in favor, respond by saying aye.
Aye.
All opposed? Motion carries. Next on the agenda is the legal report. At this time, I'll turn it over to Mr. Bryant. Thank you, sir.
Good morning, board members. The first complaint is complaint number 2024-059571. An anonymous complainant alleged that respondent had created a removal service company without registering as a body removal service. Manager of respondent establishment replied, stating that in the fall of 2023, they were approached by legal counsel of a national medical response corporation to gauge interest in facilitating the non-emergent transport of decedents from places of death to a regional forensic center.
believe I got a thumbs up. I want to make sure we're good to go.
Hello?
Someone else in the room on here? Is this your computer? Test, test. Test, test, 1, 2.
Thank you, thank you. Sorry.
All right. Sorry for the technical difficulties. Just picking up where we left off, respondents stated they agreed on a contract and that it operates solely as an ambulance service and provides no services to the consumer or to other funeral-related businesses. Respondents stated they utilize ambulances and rapid response vehicles provided by the National Corporation and that they respond via 911 dispatched operators. Furthermore, respondents stated their transport service is not staffed by funeral personnel, but by off-duty and retired police officers and emergency services personnel, and they never at any time made contact with relatives, witnesses, or associates of any nature of the deceased as a removal service would. Respondents stated it is their belief that the anonymous complaint was filed by the competitor, and that it is their understanding that they are operating strictly as an extension of the National Corporation's ambulance company and not operating as a funeral-related business or removal service. Funeral establishment license in Tennessee is exempt from registration as a removal service. Likewise, the board does not have jurisdiction to take disciplinary action against a removal service. That would be up to the district attorney in the appropriate jurisdiction to pursue an action if there were some sort of violation. So based on the above, we would recommend closure.
Thank you, Mr. Bryant. First of all, I'll open the floor for any questions or comments on this complaint.
Second.
Have an approval, a motion by Ms. Stevens, a second by Mr. Wheeler. All respond by saying aye. Aye. Any opposed? Motion for closure carries. Next case.
Next complaint is complaint number 2024-064471. This case was administratively opened following a routine inspection conducted on July 31st, 2024. During the course of this routine inspection, the inspector observed the following. The manager of respondent establishment allowed their funeral director's license to expire on March 31st, 2024, and did not meet the requirement to reinstate their license until June 24th, 2024. Respondent establishment had continuously opened during the period in which respondent lacked a licensed manager, and 4 contracts were written during the unlicensed period. The manager of respondent establishment replied, stating that while their license did lapse, it was renewed within the designated grace period, and that all required fees, including the late fee, were accordingly paid. Respondent stated it was their understanding that the purpose of the grace period was to allow licensees to maintain compliance while completing the renewal process. An understanding respondent stated they now know is incorrect. Respondent stated it was not their intent to operate outside of the license requirement. As a note to licensees, because I have seen that pop up lately a couple times about the grace period. The 90-day grace period is not intended to be a period where you may continue to practice without a valid license. Your license or licenses expire the day of expiration. The 90-day grace period puts your license in a suspended state where if you successfully renew your license within the 90-day grace period, your license is reinstated following payment of a late fee. If you renew outside of the 90-day grace period, additional steps are required to reinstate your license. Again, the 90-day grace period is intended to limit the steps in which it takes for your license to be reinstated, not an opportunity to continue practicing with an expired license. Based on the above, recommend a $500 civil penalty authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant, and also thank you for reading that additional note about licenses and grace periods. I'll open the floor for any discussion or questions.
Mr. Bryan, I'd like to ask with this, could we send a letter of instruction that the 90-day period is just that, a grace period, what you just explained to us with that, so that they understand that if this occurs again, that they have no excuse to rely upon?
Absolutely. I actually, when I read the response to avoid similar situations in the future, I actually called and spoke with this individual, but just so we have on the record that we have sent a letter written in writing communication regarding that, I'd be more than happy to do that as well.
I make a motion that we accept council's recommendation with the letter, with the instruction of the 90-day period.
I'll second.
Have a motion on the floor by Mr. Wheeler and a second by Mr. Nash to accept council's recommendation of a $500 civil penalty plus a letter of instruction. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024064481. This is the individual from the preceding complaint. This is their individual funeral director's license, but just as a refresher in case it's needed, the respondent here was the manager of the funeral establishment on the preceding complaint. They allowed their funeral director's license to expire March 31st, did not reinstate it until June 24th. They were the manager during the entire period of that time, and their establishment entered into 4 funeral contracts. And respondent just reiterated their response from the previous complaint. Based on the above, we'd recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Comments or questions?
Motion to approve council recommendation.
Second.
Have a motion on the floor by Mr. Nash, a second by Mr. Naylor to accept a $250 civil penalty authorized via consent order and formal hearing if necessary. All in favor respond by saying aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024062141. This case was administratively opened following a routine inspection conducted on November 6, 2024. During the course of this routine inspection, the inspector observed the following. Respondent funeral establishment employed a funeral director whose funeral director's license expired on June 30th, 2024, and did not meet the requirements to reinstate their license until September 26, 2024. During this time, the employee acted in the capacity of a licensed funeral director, including but not limited to arrangement conferences for 54 decedents. The inspector also included a statement from the manager of respondent establishment agreeing that the employee acted in the capacity of a Tennessee licensed funeral director during the time of the invalid license. Respondent replied through counsel stating that respondent has a robust process to ensure that funeral directors timely renew their licenses, including advance notice from respondent management to the employee and confirmation that renewal has occurred. Respondent stated that the employee was properly notified that his license was due for renewal, but that upon the employee's realization that he had not met the CE required, the employee told respondent management that after contacting the department, he was told he had a 90-day grace period. Respondent explained that based on that understanding, respondent believed that employee's license was still valid and as such did not knowingly permit an unlicensed employee to conduct license activity. Respondent acknowledged that both the employee and respondent made a mistake, but that the mistake was not intentional, nefarious, or done to besmirch the industry. Based on the above, we'd recommend a $750 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions or comment for council?
I got a question. So in now 3 complaints, we've got 2 that have mentioned this 90-day grace period. So do we know who they're talking to? And aren't those conversations recorded when they call in to the department?
I'm not
Just
sure.
there's some confusion somewhere.
Sure. I'm not sure specifically who they're speaking to, if they're speaking to the same individual or speaking to multiple individuals. I don't know for certain that the 90-day grace period is necessarily being communicated as, hey, you've got 90 days, get it taken care of, and just go about your business in the meantime. I don't know that it's necessarily being communicated that way, but it certainly seems to be how people are taking it.
Right.
And similar to Mr. Wheeler's suggestion of that, I know this is another respondent that I have spoken with, the individual on the next complaint, and have explained that to him specifically, but in that interest, I'm more than happy to also.
Well, one quick question from me. I know on establishment license renewals, funeral director, embalmers, is there a possibility, and tell me if it's maybe not feasible, to maybe send out a mass email and have TFDA do the same? I don't know if that would help get the word out. Yes, sir, Mr. Rick.
They get a letter
Right. Yeah, I understand.
telling them soon after their license expires that it's expired. But what's happening in these situations, they're not meeting the CE requirements.
Okay.
It's
Sure.
typically what's happening. They're getting their 5 hours of the 10, but not the 5 in-person hours.
Right.
And waiting till the last minute. And remember, when he reads you what the respondent says, that's what the respondent says.
Yes, sir.
And all those calls are recorded.
Yeah, I wasn't accusing anyone or anything like that. I just was
I know.
It seems like, and I guess the next complaint is related to this one, or maybe not, but it also says something about a 90-day grace period. I just looked at that, so I just seems that there's. I guess I've never thought about it being a grace period, but all right, that's my question. Thank you.
So my understanding, this occurred in June, and they did not meet the requirements until almost the end of September. Is that correct?
That is correct. Expiration occurred June 30th, so July, August, almost
3 months.
correct, yes.
So it's my understanding that this person failed to get their license reinstated because they were falling short on the continuing education. Is that correct?
That's my understanding. I know that in reading the individual's response, which is the next complaint, as Mr. Nash pointed out, that they're operating under this incorrect assumption that, okay, my license is expired, I have my 90-day grace period in which to get this sorted out, and I'm good to go business as usual. In their response, they acknowledge, I was getting very close to the end of that 90-day grace period. I thought I was okay before I got the final CE that they needed. So that, based on that timeline, basically 4 days short of that 90 days, 3 months, they're short on the CE. They're trying to get it in. They think they're okay in that 90-day grace period, but of course, as we've discussed today, they are not.
So I guess my question is this, and it might be something Mr. Haynes might answer since he is the continuing ed guy. Within that 3-month period, how many CEs are typically offered? Because I'm unfortunately, I'm old, so I'm grandfathered. I don't have to do continuing education. So I'm a little bit out of the loop on, is this something that there's like 4 Cs a month offered that these people can get, or is it just 1 hour? Does anyone know? I guess there's my question, was the availability there for this licensee to be able to get what they needed to reinstate their license?
NFDA has several programs that they offer for pre-need planning, for crematory operations, for celebrants. And you can always go to the NFDA, and they've got a course popping up all the time. It's expensive, but you get your in-person hours.
So what I'm hearing from Mr. Haynes, and correct me if I'm wrong, that the opportunity is there at any time for these people to get their CEs. So really, the monkey falls back on this licensee that they were just late. It's their fault, period.
I think that is the main crux. One thing I have heard from a lot of individuals that we've had complaints come before this board several times lately in the past few months, and they do say that they have difficulty at times finding those CEs to get the in-person. And what I think where they, and this is more just my view from what I've seen in their responses, is that your options do become more limited when my license expires in 4 days and I've got to find something in the next 4 days, as opposed to, okay, I need to find something in the next couple months, whatever. So I guess in a balance, not to take away from Mr. Haynes, because he certainly knows the lay of the land on those much better than I do of what's available and what's not. I have heard from some respondents that they have difficulty finding them at times, but recognizing that they are looking at a very shortened time frame, and also to Mr. Gribble's point that there is a heads up there. It doesn't jump out and surprise you.
So I'm gonna make this recommendation based on what Mr. Haynes has said. Sorry, Don, for Mr. Gribble and you, Troy. I mean, they weighed on 54 families unlicensed. So I think 750 is a little lax. So I would almost say the penalty, I would suggest a $1,250 fine and a letter of instruction stating that these CEs are offered throughout the year. And to me, it falls upon the licensee. If you wait and you've known since June that you're behind 5 CEs and you wait until the last week of September trying to get, that's your fault, I'm sorry. And there should be a penalty for that. That is your fault. So there's my motion.
I'll second the motion, but just to add to what Mr. Bryant said, yeah, NFDA offers these programs all the time, but if you've got to have it in like 3 or 4 or 5 days, you're screwed. They don't offer them every week, but they offer them several times during the year.
Just on our end of the state, you have 2 years to renew your license. We have 2 TFDA meetings that offer 5 in-person both times, twice a year. You've got the summer convention. Wilbert Vault in our area has an interactive. So, I mean, it's there, but the problems I'm seeing, a couple of phone calls I get is, hey, my license runs out the end of February. What do I do? So,
Yeah, and I'll say this, our state veteran cemetery in Knoxville, they offer every few months, I think it's 4 or 5 CEs, that if you attend, and so I knew of that, I just don't know, and I know NFDA offers a lot, and I know even our local associations like Greater Knoxville, they offer if you attend the meeting, it's worth X number of Cs. So the opportunity is there, and maybe the licensee ought to do a little more due diligence in researching what availability there is, because as a licensed individual, it is our responsibility to keep our license active and do the requirements that we need to do to keep these licenses active.
And one thing, sorry, I don't mean to jump in before the motion on that is called. And two, I guess I just want to iterate as well and kind of take for the benefit of this respondent individually of I think the point's been addressed on the responsibilities of the individual in this situation and their own due diligence to get the license. Just as well, just for the board to speak very briefly on kind of the responsibility of the establishment as well. So I guess from legal's perspective on that is I understand from respondents' reply, it sounds like they've got a system where, they're notified, hey, your license is coming up, you need to get that taken care of. And then it seems like here they took the word of the employee that, I have a 90-day grace period, we're okay. I'll get it taken care of in those 90 days, and they kind of just let it go. So from legal's perspective, it was kind of that professional standards conduct for if you're going to put an employee out on the floor, you need to ensure that they're a licensed individual. But I wanted to, if the board had any additional thoughts on that point of kind of the funeral establishment's obligations on making sure your employees are up to standard as well, and kind of where that comes in, because I guess the here with the individual is the next one on the report, and for the more just so to get on the record of kind of what the funeral establishment's, I guess, personal weight in that is as well.
And I agree with Mr. Bryan on that, and so I would defer this to those that sit on the board that own businesses and manage businesses, because I'm just an employee. What they do when their employees' license they know are coming up that are up for renewal.
what we do is we have what we call our Bible that we keep in the main office, and our office administrator, the first day of each month, checks every establishment, pre-need for the non-licensed folks, funeral director, embalmer, crematory, all of those licensed. And it's simple and it's all in one book, but it works.
I have a quick question. Are these two matters from the same location, or are they separate locations?
Just to clarify, are you referring to?
For the establishment, and then come up next one, and then 5, the next one, the director.
Yes, that's the same individual of that. So complaint number 4 is the funeral establishment who had this individual whose license expired. And then case number 5, which is coming up next, is the individual themselves whose license expired.
Okay, my question is number 2 and number 4 the same funeral establishment?
They are not, no.
Okay, first of all, any more questions or discussions? We have a motion on the floor by Mr. Wheeler and a second for a $1,250 civil penalty plus a letter of instruction and authorize via consent order a formal hearing if necessary. Is that the amendment we're staying with? All,
Sorry, I have one more
Okay.
question. Is this out of line of what we've done in the past?
So I do know we had a discussion the previous board meeting about, I know the board has had a growing concern with how many of these we've seen. I mean, it feels like last 8 months, maybe there are multiple every time. So kind of the phrase I keep using that it's becoming a cliche at this point. I don't want the board to feel like they're held in by previous precedent, that if there is an issue that continues to rise and continue to be prevalent, the board is certainly within their authority to adjust the civil penalty. I would say consistent with that, this is a little higher than what we've done, but that is consistent with the previous meeting.
Thank you. Call for the vote.
I'll repeat the motion and the second, just for clarity. Motion is for a $1,250 penalty plus a letter of instruction made by Mr. Wheeler and seconded by Mr. Haynes. All in favor responding by saying aye. Aye. Any opposed? Motion carried. Number 5.
Next complaint is complaint number 2024-062151. Again, just as a reminder, this was the employee from the preceding complaint. They had allowed their funeral director's license to expire on June 30th, 2024, and it was not reinstated until September 30th of 2024. During the unlicensed period, respondent acted in the capacity of a funeral director for 54 decedents. Respondent replied stating that this was the first renewal period in which the 5-hour in-person hours of CE were required for their license. Respondent stated when submitting their renewal, they were made aware that they had not met this requirement. Respondent stated they contacted the board's office to see if an extension could be given and were told that he had a 90-day grace period to complete the continuing education. Respondent took this to mean that all was fine during this 90 days and that he did not realize the license was still suspended during that time. Respondent stated if he had been made aware of this, he would have made alternate plans about his position at the establishment until the continuing education requirements were met. Respondent stated that in-person continuing education classes were, quote, almost non-existent, end quote, during this period, and that only in August was respondent able to find 2 classes to get the necessary hours, but at that time, both were canceled. Only in September, after an improved class was put together, was respondent able to receive their outstanding CE hours. Based on the above, would recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Open the floor for any questions or comments.
I just have one question, and it might be to Mr. Gribble. So if you become licensed in the state of Tennessee today, are you instructed or are you schooled on what those requirements are for the next 2 years? Your license are good for 2 years, and they'll come up for renewal, but here is what you need to meet in requirements.
Well, in order for them to get the license, they are required to pass the Tennessee Laws, Rules, and Regulations exam. So if they have studied for their exam and passed the exam, then that means they have minimum knowledge of what the laws are in order to practice. There is no CE requirement for the first renewal. They're exempt on the first renewal. It's the second and subsequent renewals where they're required to get it. I mean, we've sent out, and Ms. Bohannon can probably help me with the dates. In 2023, we sent an email to every licensed establishment, every licensed funeral director, and every licensed embalmer, every apprentice funeral director, every apprentice embalmer on what the CE requirements were for the 5 in-person hours. We followed that up again in 2024, doing the same thing again. And at the same time, if you got it, you remember it also contained information that the funeral director, a person with a funeral director's license, it was not necessary to any longer register as a pre-need sales agent. All that was in the same email. So from time to time, we do send communications to them. When the license is issued, there's not a letter it goes at that time that explains it in detail, but they've just studied for the law test.
So they've just passed their law test, which means they're supposed to be up on our laws, what the state requires. I find it a little hard to believe that this person calls the office and blames the office that they didn't explain. They took it that the grace period. I'm not defending the office, but I am, because I don't think our office would tell them, you have a 90-day grace period, go ahead and do your job. And we discussed this last month, just like your driver's license. When it says it expires on 7/1 of 2025, guess what? It's over. You can get caught driving the next day and you're driving on an expired license. That's a penalty, that's a ticket. Now, you can get your license back, and a lot of times it's dismissed. So again, I feel that this person, this licensee, has failed to do their due diligence, failed to follow the rules, and I make the recommendation that we move the penalty to $1,000 in a letter of instruction.
We have a motion on the floor by Mr. Wheeler for a $1,000 civil penalty and letter of instruction, and a second by Mr. Naylor.
This is getting old.
All in favor, please respond by saying aye.
Aye.
Any opposed?
No.
Let it be noted, Mr. Nash voted no. Motion carries. Number 6.
Next complaint is complaint number 2024-062671. This complaint was administratively opened following a formal investigative report on behalf of the Tennessee Comptroller of the Treasury. The report stated that the non-licensed owner of respondent establishment had misappropriated funds from their co-founder concurrently or subsequent to the co-founder's diagnosis of moderate to severe cognitive illness. Specifically, the findings identified that the owner misappropriated $403,600 from the co-founder by misleading the co-founder into assigning their residence to the owner via quitclaim deed upon the co-founder's passing. The owner had misappropriated $279,173.77 from the sale of rental properties that had been placed in the co-founder's trust for the benefit of the co-founder's heirs, and had misappropriated at least $4,989.28 worth of funds paid directly to the owner for the benefit of the co-founder's trust. The report also identified that the owner had engaged in credit card fraud in the amount of $14,150 from the co-founder and deceived the co-founder to write a check for $6,600, which the owner used for their own benefit, among other findings of similar misappropriation of funds. The manager of respondent establishment replied stating that all of the findings regarding the owner occurred outside of and separate from the establishment, and that this was all done without their knowledge. All of the findings of the comptroller's report involves the owner in their individual capacity. It does not appear from the report provided that the respondent establishment was involved in any of the misappropriation, other than the fact that the individuals involved, the victim and perpetrator, happened to be owners of respondent establishment. If facts were to change, where the two parties owned a different licensed business, the findings would not differ in any meaningful way. Stated differently, there is nothing that specifically connects respondent establishment to the criminal acts of the owner other than being connected by way of ownership. The owner is not a licensee, either funeral director or embalmer, and based upon provided information from the respondent's manager, the owner is currently incarcerated. A few weeks after receiving the comptroller's report, paperwork was submitted to close the respondent establishment, and based on the above, we'd recommend closure of this complaint.
Any comments or questions?
Motion to approve.
Second.
Have a motion by Mr. Nash, a second by Mr. Wheeler for the recommendation of closure. All in favor, respond by saying aye. Aye. Any opposed? Motion carries. Number 7.
Complaint number 7 is complaint 2025-001031. Complainant alleged that respondent had refused to provide their siblings, the decedent, their final resting place by disregarding complainant as next of kin. Complainant also alleged that respondent had overcharged them for cremation. Respondent stated services were provided in August of 2023, and that respondent, quote, slandered and defamed, end quote, complainant after they, quote, found out their siblings were not placed in a vault immediately following funeral services, end quote. Respondent provided no further details, complainant provided no further details or documentation. Respondent stated that primarily two separate individuals made arrangements for the two decedents' funerals and cremations, as they were the designated family members responsible for logistics. Respondent stated it is their policy to only disclose information and engage in discussions involving arrangements with identified responsible parties, which did not include the complainant. Respondent further clarified that the charges incurred were not only for cremation, but were for two funerals and subsequent burials. Respondent stated that the arrangements were expressly requested by the designated family members and that all charges were disclosed and discussed prior to execution of services. Respondent stated there was a logistical delay in transporting the decedent's remains to the cemetery, but this occurred because the two designated family members had not signed an authorization form. Respondent stated that despite numerous attempts to reach the two designated family members, they failed to respond back in order to sign the authorization forms. As a result, they were forced to hold the remains until the proper authorization was received. Respondent submitted a supplemented response stating, quote, "The arrangements were legally authorized by another family member, substantiated by the attached authorization for cremation and disposition," end quote. The authorization forms identifies the family members as another sister of the decedent and a grandmother of the decedent. Respondent also provided a written letter from one of the decedent's girlfriends and mother of the decedent's children. The girlfriend corroborated that the delay in transporting the decedent's remains to the cemetery occurred because, quote, "no one was able to reach them," end quote, referring to the two designated family members. The girlfriend stated she assisted in respondent finally making contact to have the form signed. Based on the above, it appears that respondent made reasonable efforts to receive the appropriate authorization form to have the decedent's remains buried at the designated cemetery. However, respondent designated two family members as legal next of kin, a sister and a grandmother, foregoing complainant, another sister of the decedent, as a next of kin determinant. Pursuant to applicable law, absent a power of attorney form which respondent has not provided, a surviving sibling precedes a grandmother in form of next of kin determinants, and complainant's role as next of kin should not have been foregone in favor of the grandmother. Based on the above, we'd recommend a $750 civil penalty, authorized via consent order, and a formal hearing if necessary.
Question or comments? And I've got one, Mr. Bryant, without trying to go back and read. The sister that was not included, was she aware of what was going on? Was she?
So this was one of the complaints that we got with the Attorney General's office that gets referred to us. Usually when that happens, there's not a lot of information to go on. I think the complaint was all of 4 sentences max. Based on how it read, that seemed to be the case, that she had been kind of left out and wanted to be involved in making the arrangements, and were essentially told, hey, I don't know if the family designated these two individuals or the establishment decided to go with these two individuals, but we're just basically said, hey, they've got it handled, don't worry about it. So my understanding is that complainant was aware that arrangements were occurring, made it known they wanted to be part of those arrangements, and were not permitted to be.
And we feel that the funeral establishment knew there was another sister when they did the forms and all that.
That is my understanding, yes. I'm not 100% positive of that timeline, but what I can say that I'm fairly confident in is that it's been a while since this has come up, but I think it's important to say I don't think the law is the expectation that funeral establishments have to become private investigators to find long-lost siblings or whomever. And it's at times you work because you're trying to hurry, you're trying to get these things in order and taken care of for the family as quickly as possible. At times you make a move and then realize later, oh, there's someone who should have been at the table that hasn't been yet. From there, you include them to the point that whatever steps are remaining. And from reading complainant's response and complainant's complaint and reading the reply, it seems that didn't occur. That I'm not positive what time they learned of complainant's existence, but it does seem like at no point in the process was complainant ever included.
As far as the authorizations and things like that, did the respondent provide you with copies of those documents?
They did, yes. They were very simple, straightforward, one page. Basically, it just had a spot for the individual's name, signature, and relation to the decedent. And that's how I was able to determine that a sister, and then a grandmother were made as kind of the next of kin determinants.
They didn't have any other documents, like any kind of supporting things, like any other authorizations for any other family members, or any kind of claims of authority, or anything besides that authorization.
Let me double check.
No permission to cremate signed by the family?
They did have those necessary documentation. It seems that the good news here is that complainant seems to have been on board with cremation. It was just wanting to have that seat at the table to be able to make.
So
the
they were
necessary.
just totally excluded, and the establishment never went back and asked this other sister to come in and sign off on the cremation?
That is my understanding, yes.
Okay.
So, just for my clarification, so what are we? If we're going to find them, is this professional misconduct? Is that what we're looking at here?
I would say unprofessional conduct
Professional
for,
conduct, excuse me.
I believe off the top of my head, 62.5, it's either 702 or 703, which gives you the order of next of kin determinants.
Yeah, order rights to control this. Yeah,
Yes.
I just
And so for there, kind of the clear one is if I'm a sibling of the decedent, I've got my order kind of in the priority. And then if I'm being told, hey, don't worry about it, we've got it covered, your other sister and a grandmother has it taken care of, you don't have a seat at the table,
No,
then yeah.
I understand that. I just want to make sure that I understood what the penalty was.
No,
for.
definitely so. And let me check on that documentation real quick. They had, to the respondent's credit, they had submitted a reply to, when it's with that other agency, they reply to them, and then we get the entirety of the file. So I had just a quick clarifying question for my own benefit, and then they submitted a response within a couple of days. So we got a new, I guess, slightly more thorough response a handful of days ago. So let's see. So what I've got here is the authorization form for taking charge of funeral arrangements. So this is the document, the one-page document that I referenced, where the individual signed it and designated their relationship to the decedent. So we have one for a sister. Likewise, that sister signed the authorization for cremation and disposition form, and also have a similar authorization form for the grandmother. Okay. One thing, just to make facts a little more complicated, I don't think it changes the legal distinction, but there were two decedents. There were brother and sister. It seems like there were 4 siblings in total. So the one sister, not the complainant, was made kind of the go-to person for the sister who had passed away. The grandmother appears to have been made the point person for the brother who had passed away. And so again, complainant being that 4th and final sibling, kind of from their perspective, were left out.
Did the respondent provide any information as far as was there any kind of reason? Was there any conflict? Was there just it? I understand what we're penalizing them for, but it just seems it's a little bit of a reach to me. I feel like we're reaching a little bit. I hate to say that, but
I think you've done a great job, as
Yeah, I
always,
mean-
Mr. Bryan,
yeah, I mean-
but something in my gut feeling is missing here. Now, we're both cremated?
They
Both-
were. That's correct.
So did even the only sister at the table, did she sign both cremation forms?
So-
Because both siblings would be required on both.
Let me check.
And if the funeral home didn't, that makes it a little more clear.
So looking in the response, it looks like the only cremation authorization form they attached was for the for one of the decedents. We do not have both in their reply. It was signed by the sister, not complainant, but the sister who was designated. We don't have that second one attached here, but it's I agree. Reading through it, it felt like there were pieces of the puzzle that weren't there, and I don't know if that was due to conflicts or kind of what that was coming from. But I mean, if the board has a reservation on penalizing for not including the the complainant, then will not push back on that. One thing I will say is that kind of sometimes, unfortunately, your complaints are as strong as your complainants. And when we have a complaint that's 4 sentences long that doesn't give a lot of information or attached documentation, it can put the board in a difficult position to kind of assess the situation.
It sounds like, so I'm going to make one more question for clarification. So the complainant agreed with cremation, had no objection to cremation.
That's my understanding, yes.
But we don't know if the respondent spoke to the other person or not, to the complainant. And we don't know if they established with the grandmother and the sister if they had seen if they had any kind of objection to cremation or anything.
So I know from so speaking to the sister who was included and the grandmother, they were on board with cremation. We're good there. There doesn't seem to be any tension or issue or violation there. My understanding, and let me just pull the complaint up again real quick to make sure I'm not misquoting anything here. It is all of 4 sentences. So it just says, this establishment has refused to provide my siblings their final resting place by disregarding me as next of kin. And that is essentially all it says. So I'm not...
But they have been laid to rest, correct?
Yes, they have.
Was it just not in a time acceptable to this complainant? Is that where they got upset?
I think that's part of it. I know there was
It
the
just-
issue of...
It seems like that we're into a familial issue here. That's a civil issue that has really nothing to do with the establishment, but it does with them not signing the form. So it's kind of a. Did you speak to the complainant?
I did not, no.
So we haven't got any other. We don't have a formal complaint from them. It was just to the attorney general and then transferred to us.
Well, that does open as a formal
Right.
complaint.
Yeah. What I mean is they didn't. We didn't get any additional information from them.
We did not, no.
I think that's all my questions.
And we'll definitely concede it's a tricky one because there may or may not be slight pieces of information missing. I guess what we know for certain based on the facts is that complainant is a sister of the decedent. For whatever reason, when the time came to sit down, make arrangements, sign forms, they said, okay, a different living sister of the decedent's, you have a seat at the table. Grandmother, you have a seat at the table. Complainant, you do not. Whether that determination was due to conflict, a specific reason, whether they didn't know they existed and just thought, oh, it's too late in the process, there's not much else left to do. But that seems to be the issue.
Okay. I lied. I have more questions, but sorry. Go ahead, Tim.
I guess my question is, how did the one sibling get designated as the one in charge, and the funeral home knows there's another sibling? And we all deal with families that are dysfunctional. I mean, I'll have a parent die, and I'll have 3 kids, and none of the kids speak, and we're going to cremate. I bring all 3 kids in at different times, and they all sign my form. I do not cremate without their signatures. If I have knowledge that they're, and the same way would be with siblings. If I have knowledge, and from what I understand, the complainant let the funeral home know they were a sibling, and the funeral home said, well, I've got your sister and I've got your grandmother and I don't need you. So there is a little bit of responsibility felt to the funeral home because there is the order that we're to abide by when we are cremating who is the legal next of kin.
Got it. I agree with that. I've just read back, and so it says that this happened in August of 2023, and
That's correct, yes.
the complainant also alleged that the respondent had overcharged them for cremation, so they were financially responsible for these things, but they didn't sign to any kind of authorization.
So based on what I'm understanding, and I think this is legally speaking, probably the weakest pillar of complainant's complaint is they're alleging that the family members that were designated were overcharged, but then that kind of a catch-22 of if you weren't at the table, and to respondent explains, it wasn't just a cremation, it was burials, services.
And it was a brother and sister that passed away.
Correct.
Did they pass away at the same time, or do we know anything? I mean, is there just
I would assume so, but I don't know that for sure.
and so do we know for sure if that because it sounds like these two people that passed away didn't have any spouses or children. That's what it sounds like to me, just in my assumption. So do we know for sure that the grandmother or the other sibling did not have sort of power of attorney for health care, or they had right to disposition, or any kind of other documents saying?
Do not know that for 100% certain, but in both responses, that documentation was never attached. I would assume if they had it, they would have added it, but
My assumption too.
So I would like to know who signed the brother, the male that passed away, who signed his permission to cremate? Because, so you tell me you received only the one on the sister, that sibling. It was signed by the sister. Then my question is, did just the grandmother sign the brothers? If so, they were totally out of line in getting their next of kin signatures. So I'd almost recommend we go back and ask for more documentation to answer some. And who signed the statement of goods and services? If this one's complaining about being overcharged and her signature doesn't lie on the goods and services, I'm not sure she has a dog in that fight if she wasn't responsible for paying. Now, I'd like to know who paid the bill.
Mr. Wheeler, I agree with you, and what I'd like to do is make a motion to table this to the next meeting, or whenever you get the total information for the board. That's my motion to table this at this time.
Second.
Have a motion on the floor to table complaint number 2025-001031, and a second by Mr. Haynes. In lieu of additional information, I am assuming we want to see the cremation authorization on the sibling and maybe just get a more detailed answer from the respondent as far as when he knew there was another sibling. Is that kind of where we're at?
That and clarification if there's any documentation they didn't include as far as a power of attorney.
Yes.
That would change the whole thing.
President Lee, I don't think that we can see those documentations, but Mr. Bryant
Brian could, I mean, I'm sorry.
can. Yeah, okay, thank you.
And a statement of goods and services for both. Since it was two services, there should be two statement of goods and services for each deceased individual. I'd like to see both. I'd like, or not me, but you see, to get clarification. Who signed, who was responsible? My question is, they were more than apt to send the one on the sister that died, the documentation of cremation, but they failed to send the brothers. And I'm questioning, why did you not include both?
Got a motion and a second. Through all this, Mr. Bryant, do you have an understanding of what you're going to do, sir?
I do, yes. Taking notes. I think we're good to go. We've got our
Thank you,
directive.
sir. All in favor of motion of tabling till the next board meeting, please respond by saying aye. Any opposed? Motion carries. Number 8.
Next complaint is complaint number 2024-067281. Complainant alleged that respondent had engaged in advertising violations. Specifically, complainant stated that their funeral establishment were made aware that they had been named winner of their city's, quote, best of reader's choice in 2 categories, best funeral home and best cremation services, end quote. Complainant stated that the official results were published on October 28, 2024, listing complainant as, quote, winner, end quote, and respondent as a, quote, finalist, end quote. However, complainant alleged that on November 27, 2024, respondent had advertised itself as, quote, winner of the best funeral home category through billboards, social media posts, and on-site signage. Complainant stated they contacted respondent on the same day, providing proof of the official results, and requested that respondent change their advertising, but claimed that respondent incorrectly claimed they were the, quote, winner of the category and directing them to the city press. Complainant stated they confirmed on December 3rd, 2024 with the press that respondent had been aware they were a, quote, finalist, but not a, quote, winner, and that complainant was the winner in both categories as determined by the local press. Complainant attached the designation from the press identifying complainant as the winner and respondent as a finalist, as well as photographs of the billboard and social media posts. In this photograph is one of the staff of respondent establishment holding a banner provided by the press stating, quote, "We were voted the best in the city's Press Reader's Choice 2024, with the press's emblems in the top corner stating, quote, Reader's Choice, the best of 2024, end quote. Complainant provided screenshots and photographs of a social media post with the same emblem from the press stating, quote, thank you, city, for voting us the best, end quote, and other such similar language. The manager of respondent establishment replied stating that both establishments competed in the, quote, best of the city, end quote, competition, with complainant placing first and respondent placing second. Respondent stated that in no way were they attempting to take away from complainant's accomplishment. Respondent stated in September 2024 they were made aware by the press they were a finalist in the press's best of competition. Respondent stated they worked with the press to complete an advertisement in the publication, and a representative from the press came and photographed staff holding a banner stating, quote, we were voted the best in city, end quote. Respondent stated they were also presented a plaque engraved, quote, best funeral home cremation services, end quote, and that the photographs were posted to social media after the winners were announced in accordance with a media kit provided by the press. Respondent stated that the press also provided them a logo to use on their advertisements. Respondent provided it was their understanding that posting of photographs on social media platforms and use of the logo is acceptable when used by finalists in these type of surveys, and that the press stated they could not place the word winner in their advertisement, and thus that language was not included. Respondent stated they used similar language in their billboard advertising as the other advertisements and did not indicate that they were a winner of the competition. Based on the above, it does not appear to legal that respondent has violated applicable funeral laws or rules. While legal understands complainant's concern regarding usage of the word best, which may imply winner, the competition ran by the press was named, quote, best of city name Reader's Choice 2024, end quote. The press has evidently decided that the words winner and best are distinguishable titles and certificates. One must be voted first in a particular category to be called a winner. One must be voted at least a finalist to be called best. While this may go against the plain understanding of the word best, given that the competition is called, quote, best of city name, end quote, it makes sense for a placing business to receive the distinction of best, even if they were not categorized as winner. This is further demonstrated by the fact that the press themselves provided respondent with the language and emblem to use indicating they were voted, quote, best, but cautioned against calling themselves winner. If complainant has qualms with how the press is using the designation of the word best, that is better suited to be taken up with the press of that city and not this board. In short, respondent establishment was provided with a designation of being, quote, the best of city name, end quote, as decided by readers in 2024. Respondent used the designation they were given by the press. Respondent did not use the designation of winner that they were not given by the press. As such, there are no discernible violations for using a designation given to a funeral establishment, even if it may be argued that the distinction of the designation could be confusing to the general public. As previously stated, such concerns are better addressed to the city's press rather than this board, and thus we'd recommend closure.
Could you read that again?
Yes.
Legal's recommendation of closure.
Second.
I just want to compliment Mr. Bryant on that very thorough
Seriously.
legal explanation.
And I'm sorry you even have to deal
In
with
best and winners. Thank you
stuff
so
like
much.
this.
There-
Unless we have a timeout corner.
There will be a test at the end of what best and what winner means, so.
Forgive me, I think I have a motion by Ms. Stevens and a second by Mr. Nash to recommend, I'm sorry. Mr. Wheeler and Ms. Stevens. Okay.
I did the motion.
Okay.
I did second.
Have a motion by Ms. Stevens and a second by Mr. Wheeler for recommendation of closure. All in favor respond by saying aye. Aye. Any opposed? Motion carries. Number 9.
Next complaint is complaint number 2024-067331. This case was administratively opened following a routine inspection conducted on November 5th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent establishment submitted an establishment closure letter on October 29th, 2024. However, respondent conducted or planned to conduct funeral visitation services for 4 deceased persons after submitting the establishment closure letter. Respondent stated that for one of the identified services, the arrangements for a decedent were done at respondent establishment on October 27th, 2024, and that the establishment didn't close until October 29th, 2024. For the other 3 cases, respondent stated that these 3 were handled by a sister funeral home at its location at that time. Respondent stated the families all chose the chapel at the closed respondent establishment to have their service, and respondent saw no issue as no business was being handled at respondent establishment during that time. Respondent added there was a licensed funeral director on site for the service, just like any other service held at any other facility. Respondent explained they were only conducting the service of their sister establishment at the chapel, and that business was not being conducted at the closed respondent establishment, just the use of the chapel space for the services. And second finding is during the time of the inspection, an employee who had written 3 pre-need funeral contracts was not registered as a pre-need sales agent. Respondent stated that this was an oversight as most licenses and registration are filed with the corporate office. Respondent stated the employee was newly licensed and didn't know that they needed to see if the registration had been completed. Respondent provided that this was corrected the day the inspector was on site and that the fee was paid that same day. As a slight addendum from legal, based on the obituary obtained during the inspection, according to respondent, the arrangement conference for one decedent occurred on October 27th, 2024. Respondent establishment closed on October 29th, 2024, and visitation and memorial services occurred on October 31st, 2024. So, based on the above, would recommend a $750 civil penalty, authorized via consent order, and a formal hearing if necessary.
And this establishment is closed
Correct.
now.
So essentially, in looking at what our investigator found was that, okay, 4 services were held at this location after it was closed, after they closed up shop. Was only able to get the obituary for 2, so we only have evidence of the 2. One of them said, to keep anonymity here, we'll say this one is establishment A and establishment B. So they're saying, oh, our sister establishment B handled those other 3, and that seemed to match the paperwork, that the family wanted to just use that space, and I don't think that is a violation. I think that's okay. But that first one, the obituary identified that, and respondent agrees, we closed up shop October 29th, 2024 was our last day. The obituary says that services were held there on the 31st. So they have one for certain where they just sent in their closure letter a little too early. Because once that's gotten in process, you're closed. And then, again, the individual without a license, pre-need seller registration, pre-need sales agent.
Second.
We have a motion on the floor by Mr. Nash, a second by Mr. Wheeler, to accept council's recommendation of $750 civil penalty, authorized via consent order, and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 10 and 11, I think.
Yes, this is the same individual, complaint number 10, which is complaint 2025000551, is the respondent's funeral director's license, and the second one, which is complaint 2025001921, is the respondent's embalmer's license. Complainant alleged that respondent had stalked himself and his girlfriend and abandoned a work vehicle with the decedent in the back of the van. Complainant stated that respondent was ultimately arrested and charged with stalking and evading arrest. Respondent replied explaining that his ex-girlfriend was cheating on him with complainant at the time and caught the two together. Respondent admitted to being in a funeral home vehicle the night he was arrested when stopping by complainant's residence. Respondent was ultimately terminated from his employment at respondent establishment. Respondent admitted that at the time there was a decedent in the vehicle at the time he stopped at complainant's residence while investigating to see if his girlfriend was cheating on him at that time. Following respondent's arrest, the work vehicle with the decedent was transported back to the funeral home by a coworker, and the decedent was placed in the cooler. Respondent said the decedent was never out of his sight the entire time the issue occurred. Respondent pled guilty to the stalking charge, but provided documentation to show that the conviction has been expunged as of January 16th, 2025. Based on the above, respondent admits to stopping at complainant's residence to investigate whether his girlfriend was at the residence at that time while in a work vehicle. Respondent further admitted that the decedent was in the back of the work vehicle at the time he was at complainant's residence. This would qualify as a violation of professional conduct for both licenses, funeral director and embalmer. The stalking conviction was not a felony, nor is stalking considered a crime of moral turpitude involving fraud or dishonesty, and as such, respondent was not required to notify the board of the stalking conviction pursuant to Rule 0660-01-0.03, subsection I. So based on the above, we would recommend a $750 civil penalty to be assessed against the funeral director's license and a $750 civil penalty to be assessed against the embalmer's license, both authorized via consent order and formal hearing if necessary.
So many questions in my head here, but
Me too.
my discussion is this. I mean, I know, I guess legally the moral turpitude's not in there, but good grief, there was a decedent in the
Yeah.
van here. And if I'm not mistaken, I think it's okay to say this. I think we heard the funeral establishment last month, and they did right in what they did.
That is
So we're
correct.
dealing with the employee.
I don't care what your situation is personally. When you take a decedent into your care, you have an obligation to ensure that they are cared for properly.
Absolutely.
I make a motion to increase each penalty to $1,000 per license.
Second.
I have a motion by Mr. Nash, second by Ms. Wheeler, to increase the civil penalty on the funeral director and the embalmer's license to $1,000 each. Quick question. Has the board ever, or is there anything with cases like this that maybe they could be put on probation or something, or see if, kind of worries me about dealing with domestic and I don't know, and the penalty may be
And-
what you recommend.
I think too, in the event that anything occurs with this individual in the future, this consent order will be on his disciplinary history. So if this individual ever comes back, we will know that it's.
Thank you for the clarification. All right, all in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 12.
Last complaint is complaint number 2025-000-411. Complainant, daughter of the deceased, stated that her father passed away on December 20th, 2024. On December 23rd, 2024, complainant's mother met with the funeral director at respondent's establishment and discussed cremation of the decedent and signed the appropriate authorization form. Complainant stated at no time during this discussion did the funeral director ask complainant's mother what should be done with the decedent's valuables, specifically his jewelry on the decedent. Likewise, complainant stated that the authorization form did not contain any information that indicated what should be done with personal effects. On January 3rd, 2025, complainant's mother received a call from respondent informing her that the death certificates were available, and during this conversation, the mother asked when she would be able to pick up the decedent's jewelry. Funeral director informed complainant's mother that because instructions were not explicitly given to respondent to return the jewelry, they were cremated with the decedent. Complainant stated they later called the funeral director and said it was unacceptable for respondent establishment to assume the family wanted decedent's jewelry and things cremated. Complainant stated the funeral director admitted he did not ask the mother how to proceed with the valuables found on the decedent's body and assumed she wanted them cremated with him because she did not bring it up during the conference. Respondent replied, stating that during the arrangement conference on December 23rd, 2024, the mother of complainant did not wish to view the decedent again and did not request for any personal items to be removed from the decedent. Respondent stated identification was done by photo provided by the family. Respondent largely reiterated the narrative as complainant had explained, identifying specifically complainant inquired about a bracelet and a ring to be removed from the decedent. Next, however, respondent stated complainant called their establishment a second time, accusing them of stealing the decedent's personal belongings and claimed that the decedent also had a necklace. Respondent stated that the EMS confirmed that the decedent was not wearing a necklace, and this was confirmed with scene photographs. Respondent stated on January 7th, 2025, The complainant came to their funeral home to pick up the cremains, and at that time, the complainant was shown the personal items in question that were on the decedent's person during cremation, a ring and bracelet, that were returned with the decedent's cremains in a separate bag. Respondent reiterated that complainant was not the next of kin and did not take place in any of the arrangement conferences, and that it is not uncommon for individuals to want their loved ones buried or cremated with jewelry and personal items on them. As such, the jewelry was left on the decedent when EMS took the decedent into their care, and that the mother and wife of the decedent never expressed to them her wishes for any items to be removed. Legal spoke to the mother/wife of the decedent. After a brief conversation, the wife very much shares the feelings of complainant, her daughter, and stated that the complainant only filed the complaint on her behalf because of the grief and mind fog that had occurred with the incident. Complainant filed a rebuttal stating that in total there were 3 rings, 2 on his right hand, a wedding band, and a copper bracelet on his left hand, and were all jewelry that he never took off. Complainant stated the medical examiner advised that there may be a necklace, but mentioned that it was not visible in photos. Complainant also points out that respondent admits in the reply that they did not ask her mother, wife of the decedent, how she wanted the items on the decedent to be handled. Complainant stated that evidently there are no checks and balances in place to determine that the correct decision regarding personal effects is made, and that they only rely on assumptions. Based on the above, we'd recommend a $1,000 civil penalty, authorized via consent order, and a formal hearing if necessary.
One quick question. You spoke with the complainant. Is everything okay as far as restitution, or was that even brought up, or?
So just as a clarification, the complainant is the daughter of the decedent and the mother. And I spoke with the mother because kind of respondent's take was, well, sure, the daughter is complaining about it, but the mother was the next of kin. And if the complaint doesn't come from them, then. So I wanted to make sure, do you also feel the same way? And she did. That was not brought up. The wife of the decedent and I spoke for probably about 20 minutes. Did not mention restitution, or it just didn't come up at all.
Thank you, Mr. Bryant. Ms. Nash?
In this, it says, January 7th, 2025, the complainant came to their funeral home to pick up the cremated remains, and at that time, they were shown the personal items in question that were on the decedent's person that were returned, a ring and a bracelet. So 1 ring and a bracelet were returned?
That confused me when I read it. I'm not sure if that was what was left of what was.
Returned after cremation, I'm guessing. I'm wondering.
Right.
That's possible, but also and it said that was not wearing a necklace was confirmed and seen photographs where the photographs able to confirm that the decedent had the rings and the bracelet on.
That wasn't mentioned by either party. It seems like parties agree that. I think the necklace kind of got dropped along the way, but
Sure.
Seemed to agree. Yes, he had jewelry on him, wedding band for certain, rings, bracelet, and I mean, respondent acknowledges we didn't ask. We assumed they didn't bring it up.
Sure.
So we just cremated the decedent as we received them, and then I guess complainants, just to narrow down, make it as simple as possible. Complainants' argument is just that that's a violation of unprofessional conduct by not just one. The mother repeated the phrase, one question. That's all it would have taken.
I don't disagree with that at all.
Sure.
I just want to clarify. When it says that there were certain things were returned, were they returned after cremation? It sounds like they probably were.
That is my understanding, that they were returned after cremation.
And what was the other question?
And so this is directly against the funeral establishment, not the funeral director.
Correct. Yes.
Any more questions or comments? If not, I will entertain a motion.
I make a motion to accept.
Second.
Have a motion on the floor by Mr. Nash, a second by Mr. Wheeler, to accept a $1,000 civil penalty and authorize via consent order and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Mr. Bryan, as always, thank you for your hard work in making this where we can understand it. I appreciate it. Next on the agenda is we have the Executive Director's report, and at this time, I'll turn this over to Mr. Gribble.
Thank you. Good morning, board members. First thing we have is a legislative update. Before you, we have 3 bills that 2 are directly affect this board. One is kindly affects funeral directors in general, but not specifically to the board, but we thought you would probably want to be aware of it. And also mention to you that there are many other bills out there that has to do with estates and other things. So that's why we have the website search at the bottom so that you can go and look and see, search for whatever word you want to, funeral, trust, cemetery, embalming, whatever you want to see other bills. The first bill we want to talk about is House Bill 0860, Senate Bill 1149. As introduced, authorizes the funeral director applicant who is not previously licensed in the state to substitute 1 year of apprenticeship with an associate degree or the completion of a program of study in funeral service education. So basically what that does is changes the apprenticeship time from 2 years for an apprentice funeral director to 1 year. Same as it does for an embalmer who gets an associate degree. That is already there. So this would correlate or match that. It doesn't change the education requirement. It only changes the length of time that they would serve. In other words, I think the emphasis or goal behind it is to get more funeral directors licensed in a shorter period of time to help with the workforce and to have funeral homes to have funeral directors in place. House Bill 1286, Senate Bill 1145 regarding death, as introduced, requires that if a person or government agency assuming custody of a body for the purposes of burial does not request an autopsy or that the body be embalmed, the person or agency to ensure that the body is buried within 48 hours from the time when the person or agency waives the ability to request an autopsy or embalming of the body. Of course, the key definition there is in person, that's the funeral director or funeral home. So that obviously there's no timetable in place now under current law that requires the body to be, an unembalmed body to be buried in a certain amount of time. This bill would do that. It doesn't mention anything in the bill itself about refrigeration as being an alternative. It just says that the burial will occur within 48 hours. And the last bill we have listed is House Bill 0713 and Senate Bill 0715 pertaining to cemeteries. As introduced, changes the way the fair market value in the Improvement Care Trust Fund is calculated for certain purposes, clarifies that the fee that a cemetery company charges for memorial care of a commodity installed in the cemetery cannot exceed the fee charged by the company for the installation of the commodity, and makes other changes related to cemeteries. And keep in mind that these are the bills as they're introduced. You have a copy of each one of them there in your packet, and of course those were emailed to you and with the information that was sent with the documents today. And what I wanted to add to that is many times we see bills introduced, and as they work their way through the legislative process, the bill may get amended. So typically this board doesn't take a position on any bills, but you have these and you're aware of them, and if you want to, if you have your own interest to convey your personal thoughts to your state representative or state senator, then you have the knowledge of what the bills are. And like I say, there are many, many others there as well. But if you have any questions about that, we'll be glad to answer those.
Sorry. House Bill 1286, do we have any, how that came about or what brought that up? Is there some sort of situation that's occurred?
My understanding was it was a situation that came up in a rural area, and the person in charge did not want to bury the decedent as soon as another family wanted the decedent buried. And they must have had, as Mr. Wheeler mentioned earlier in something else, a dysfunctional family that could not agree, and evidently from what I'm told, and I don't know that to be true, Mr. Nash, but that's what I'm told is what.
Seems like if you especially if a funeral home is a very busy place, it puts a lot of burden on the establishment to make sure those things happen. If you have multiple situations that arise like that at once.
And the bill doesn't currently, in its current form, doesn't address cremation. So Mr. Bryant and I were talking about there might be times that even if the funeral director could act within 48 hours, they might not be able to schedule a cremation within 48 hours.
Right.
And if you've got refrigeration, it's not unheard of to have an immediate burial outside the 48-hour range in case family members had people out of town. So, yeah, the initial reading of this bill, to me, leaves a lot to be desired.
Was this bill brought before a constituent or an organization?
My understanding is the sponsor did it on behalf of a constituent, of an individual. Probably the affected individual in that scenario that we just talked about. But that's not my personal knowledge, that's just what I've been told. Next is a report of licenses administratively approved by the Executive Director pursuant to Port Authority for the period of January 11, 2025 through February 7, 2025. You have a list of those there in front of you on those. Closed establishments. This month we have 2 to report closed. Church and Chapel Funeral Service, LLC, 103 Highway 259 in Portland, Tennessee, and Cox & Son Funeral Home Incorporated, 418 5th Street in Jellicoe, Tennessee. The latter one, they had a building, their building caught on fire, had extensive damage back some months ago, and we've been working with them, and they made a determination instead of trying to relocate or to build back, the owner notified us and sent in the closure documents to close the business. Disciplinary action report for this board meeting is a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to board authority, and these were as reported on the December 2024 disciplinary action report of the regulatory boards, and you have those listed there for you as well. And last is the complaint numbers for this board meeting. We have 69 complaints that are open, 34 of those against funeral directors or embalmers, and 35 against establishments. That concludes my Executive Director's report, Mr. President. I'd be glad to answer any questions.
Thank you, Mr. Gribble. Any questions or comments?
Make a motion to approve.
Have a motion by Mr. Nash,
Second.
second by Ms. Stevens to approve the Executive Director's report. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Ms. Bohannon and Mr. Gribble, do we have any individuals or establishments to appear before the board?
There are none today, sir.
All right. Move on to new business. I think Mr. Gribble's going to give us a report on the self-sufficiency hearing that he and so kindly Mr. Wheeler stepped in and rescued us and attended on our behalf. Mr. Gribble?
Thank you, sir. Reed Witcher, Assistant Commissioner for Regulatory Boards, Candace Dawkins, the Legislative Director for the Department of Commerce and Insurance, myself as the Executive Director, and Mr. Wheeler as the board member, represented the Board of Funeral Directors and Embalmers and participated in a self-sufficiency hearing before the Joint Operations Committee on Thursday, January the 27th, 2025. The hearing was held in pursuant to Tennessee Code Annotated 4-29-121 to demonstrate the board's continued financial self-sufficiency. This included a presentation by the Assistant Commissioner, and one of the committee members asked a question, had an inquiry, and I responded to that and answered their question. And there was an opportunity for public comment. No vote or other action was required by statute for this hearing. However, the Joint Operations Committee always has the opportunity and can subsequently introduce legislation based on the information presented. Video recording of that hearing and additional information is available at the link that's given there to you. Something I think that would be beneficial to the board for me to mention that that we knew but was confirmed during that hearing. And you'll remember last month we talked about in detail about financial information and data about the board. So if the board's reserve is less than 1 year of operating expenses, then it's the department's recommendation to the board to increase fees. If the reserve is greater than 2.5 years of operating expenses, then it's the department's recommendation to the board to decrease fees. Now, this board has about 1.4 to 1.5 years of reserve. So in other words, if we didn't collect any more money, if for some reason something happened, we didn't collect any more money, we have enough in reserve that would equal to about 1.5 years of operating expenses for the board. So the good news is we're above the 1 year. So because last month we talked about there'd be further discussions about and maybe recommendations as to what the board should do. So in consultation with the assistant commissioner, the recommendation is just to set still, not raise fees, not decrease fees, see where things go. And so the good news is there's no recommendation to increase fees. The bad news is there's not enough money in reserve to have a recommendation to decrease fees. So there has to be some humor in all this financial stuff somewhere.
That good, Mr. Ribble?
And Mr. Wheeler may have something to add to that. I think he, from his personal experience of being there, he may have some comments. I don't know.
I'll say this, it was a great experience. I enjoyed it very much on short notice. What probably surprised me more than anything was the House and Senate did not realize about the penalty fees. That surprised me. There were several questions with other boards about they didn't realize there's a penalty when you let your license lapse. So I think it was a learning experience for them at the same time it was for me.
Any other comments, questions? Thank you, Mr. Gribble and Mr. Whaler. Ms. Lisa, did anyone sign up for public comment today?
There are no people asking for public comments, sorry.
Mr. Batson, Mr. Lee, any insight back there? Always good to have you. If there's no other business to come before this board, I'll entertain a motion to adjourn.
I have a question. What time is our meeting on March 11th? Is there a change in the time?
As far as I'm aware, that's the same start time.
At 10
a.m.
o'clock?
Correct, yes.
Okay,
Are
thank you.
we set for that special hearing?
That is my understanding. I have not received a scheduling order officially setting it in stone, but I have heard nothing to the contrary that it will be set for March 11th, 12th, and 13th. I'm happy to reach out to the ALJ to confirm that, but like I said, last we spoke, that's what
It's
it.
9 o'clock.
The board talked with the ALJ about starting at 9 o'clock.
Yes, that it was 9 a.m.
Okay, if that's the case, I mean, if the board has had conversation with the ALJ that I have not, then I would say err on the side of 9 then, but I will reach out to the ALJ to try and confirm, and as soon as I hear something for certain, we will let the board know.
That discussion was while you were busy at the last meeting, but it was during the hearing at the last meeting. At the very end, I can't remember who it was, maybe Ms. Stevens, Mr. Wheeler, somebody sitting near the judge spoke up and said, in order to move it along, if they could start at 9 o'clock, that would be helpful.
And I guess since that was when.
Or have time for it to.
Right. I guess that's when we thought we were going to come back on January, and weren't able to, unfortunately. So I would say, just to be safe, better to be earlier than late, err on the side of 9 a.m., but I will reach out to the ALJ to try and confirm that one way or another.
Any other questions or comments? Then I will entertain a motion to adjourn.
So move.
So move second. All in favor, respond by saying aye.
Aye.
Any opposed? Motion carries. Thank you all. Bob's fault they don't have no CU classes.